Okay, good evening everybody and welcome to this meeting of Cheltenham Borough Council's Licensing Miscellaneous Subcommittee, which is being held today, Wednesday the 6th of November 2024. My name is Councillor Dr David Willingham and I am Chair of the Committee. So first, a few housekeeping things. The meeting is being streamed live to Cheltenham Borough Council's YouTube channel, and a recording of the meeting will be held for 4 years. If there are any breaks in the transmission to the YouTube stream, then the meeting will be adjourned for a short period until any technical issues are resolved. Noting that there are some opt-outs because of effectively public safety concerns. To the public present, if you are here to make a representation to the meeting, you are consenting to the use of the sound and the video recordings for broadcast and training purposes. And as I said, there are, I believe, some speakers who may have opted out of being on video, and we've agreed that. Please also be aware there's CCTV and audio recording in operation in the public gallery, and the recordings there will be held by the council for 5 months. There is no fire alarm test expected, so if the fire alarm does sound, you should make your way immediately to the nearest exit, which is where the green signs are where you came in, and there's also another exit behind me there. And our staff and councillors will make sure that the public have been able to get out. If you've got a mobile phone or a computer that makes noises, could I ask you to put it in silent mode? And I think that's covered all of the housekeeping. So, moving on to the main agenda. Agenda item number 1 is apologies for absence. So, apologies have been received from Councillor Boyes, and Councillor Steinhardt is attending as a substitute. Agenda item number 2 is declarations of interest.
Yes, I know one of the speakers, Chair.
And we've confirmed that that's not a prejudicial interest. So, because there's so many people here, if I can just ask my colleagues and councillors to introduce themselves so just people know who's speaking. So, if I can start with you, Julie, and then we'll go.
Yeah, Councillor Julie Sankey.
Councillor Steve Steinhardt.
Councillor Simon Wheeler.
And Councillor Helen Pemberton.
And if I can ask my officer team to just do the same as well, just so everyone's got clear.
Louis Krog, Head of Public Protection.
Vicky Fennell, Legal Advisor to the Committee.
And the 2 officers, I don't think you've got microphones, but have you? There we go. My Democratic Services.
There we go. My name's Claire Morris. I'm a Democratic Services Officer.
And my name is Rhianne Watts, and I'm also a Democratic Services Officer.
Right, so agenda item 3, we have briefing notes. So you'll find that there is, as of the full committee, which was in September, I was asked to send a letter to the new Secretary of State calling for a review of the Local Government Miscellaneous Provisions Act 1982 related to the frequency exemption of sexual entertainment venues. That letter is here in the public domain. It was sent by email to the Home Secretary on the 3rd of October, and as of about half an hour ago, no reply had been forthcoming from the Home Office or the Secretary of State. It's also worth noting that Town's MP asked a question, which is linked in the response is linked in the letter in the footnotes. And finally, I would like to welcome Michelle, who is our new licensing manager, I think was the title, who's joined us from another authority in Gloucestershire, and obviously welcome to the licensing team. Right, now we move on to the substantive item, which is agenda item number 4, which is an application for the renewal of a sexual entertainment venue licence. So for members present, because this is a regulatory item, you must be present and have heard the proceedings in their entirety to vote on this item. The process will be as follows. So we will ensure the applicant and the applicant's representative are present in the meeting. We'll also ensure that objectors and other speakers are here, which we've done. I will ask the licensing officer to introduce the report. Members will get an opportunity to ask the licensing officer questions. Then the applicant will get an opportunity to ask questions, as will objectors, if there are any questions arising from the report. We will then give each objector an opportunity to speak. Because of the number of people, we've asked everyone to limit this to no more than 5 minutes. Hopefully there will either be a timer on the screen or the lights in front of me will give an indication of... Right. And the light should indicate yellow for please bring your remarks to get ready to finish, and red for bring your remarks to a close. Members will get an opportunity to ask the objectors questions based on what they've said, and then we will hear from the applicant. And again, members will get an opportunity to ask the applicant questions. We will obviously have some comments in front of you as members. We may need to go around this process again. The applicant will be given a final right of reply, and the likelihood is we will adjourn to take legal advice and go through our decision, and then we will come back and give you the decision. Just to be clear, there's no cross-examination in this process. So with that, if I can invite the Head of Public Protection to introduce the report, please.
Thank you, Mr. Chair. So, Mr. Chair and members of the Licensing Committee, under Schedule 3 of the Local Government Miscellaneous Provisions Act of 1982, anybody can apply for an application or to renew an application for a sex establishment licence. In this case, an application for the renewal of a sexual entertainment venue licence was submitted to this authority on the 9th of September this year in respect of number 30 Cambray Place in Cheltenham. At point 1.3 of the officer's report, members will see the times and dates for which the application relates, and if granted, the licence will have effect for. At 1.4, members are to note, in addition to the times and dates specified, the applicant has also applied for a number of standard conditions to be varied as part of the application today. Will be a variation on the standard conditions that we specify in our licensing policy. In terms of consultation, an application for a sex establishment licence must give notice of application in accordance with the requirements set out in Schedule 3 of the 82 Act. These were complied with. Members are to note in particular that any objections must relate to the mandatory and discretionary grounds for refusals as set out in the report. And in determining the application, the legislation makes clear that members must have due regard to any observations made by the Chief Officer of Police and any other comments made by anybody else. In terms of the consultation, members are to note that the Chief Officer of Police have made no objections or any comments in relation to this application. In terms of other people, the authority received 74 objections and 40 representations in support of the application. At point 4 of the officer's report are relevant extracts of the authority's adopted policy. I draw members' attention to 4.3 that states that as a regulatory matter, the authority doesn't take a moral stance on adopting this policy, and therefore also the applications it determines under that policy. The authority recognises that Parliament has made it lawful to operate sex establishments and that such businesses are a legitimate part of the retail and leisure industries. It is the authority's role as licensing authority to administer the licensing regime in accordance with the legislation. At 4.5 of the report, members are to note the statutory discretionary grounds for refusal, and as previously stated, any decision-making or any deliberation in relation to this application must relate to the discretionary grounds for refusal. In terms of the policy position, members are to note at 4.6 that the authority's position is that we will not license SEVs in the majority of the town, but in the area that's known as the permitted area that's outlined in the officer's report. The authority takes a different view, and for applications within the permitted area, we will deal with those on a case-by-case basis on its individual merits. At section 5 of the report, members are to note the national guidance that accompanies the licensing of sexual entertainment venues. Just draw members' attention again to 5.6 of the report that says, and this is an extract from the guidance, the national guidance, that objections should not be based on moral grounds or values, and local authorities should consider the objections that are not relevant to the grounds set out in paragraph 12. So just to reiterate that your deliberations are essentially restricted to the discretionary grounds for refusal. And at 5.7, it says, when determining licensing applications, the local authority must have regard to any rights the applicant may have under Article 10 and Article 1 of the Convention on Human Rights. Just in terms of public sector equality duty under point 6, this licensing regime does fall within the authority's public sector equality duty. As part of your deliberations and your decision making, the committee needs to have regard to your public sector equality duty as set out in section 6 of the report. And in terms of your decision making, you must be mindful of that duty and to comply with that duty. And then just finally, in terms of officer comments, this application must be determined on its individual merits, taking into account the matters outlined in this report, the relevant statutory provisions, the authority's adopted policy, and the guidance issued by the Secretary of State. In particular, the committee must bear in mind that the grounds for refusal of this licence application is restricted to those specified in the statutory, mandatory and discretionary grounds. The committee is also reminded that the authority does not take a moral stand in relation to operation of sex establishments, such as sexual entertainment venues, because the authority recognises that it's a legitimate form of entertainment. It's the authority's role as licensing authority to administer the licensing regime. The application is also seeking to vary the standard SEV licensing conditions. The committee must not arbitrarily deviate from its own adopted policy. Where the committee considers there to be an exceptional circumstances, it may justify deviation from its licensing policy, but these must be thoroughly reasoned and recorded in your decision making. Members are to note that the premises at number 30 Canberra Place falls within the authority's designated permitted area for licensing of SEVs. And then just finally, the committee can decide to grant the application in its entirety, can decide to grant the application with any additional terms, conditions or restrictions that you deem necessary, or you can refuse the application as part of the decision-making powers you have. And then just finally, which has been referenced, in terms of compliance history, it is worth members to note that a complaint was made in relation to the March races, in relation to advertising, but it will be, I think, referred to in the presentation by one of the objectors. But it's just to make members aware that in terms of compliance history, there was the one complaint in March, and I'm sure the applicant will also respond to that. Thank you, Mr. Chair.
Thank you. Are there any questions from members? Councillor Wheeler.
Yes, based on the comments you made, Chair, about the letter that's gone to the Home Office, I think I'm right in saying that should we choose to refuse this application tonight, the applicant could still operate, albeit in a limited way, but with no conditions, checks or balances by us, the council. I think I'm correct in saying that, yes.
The frequency exemption. I'll ask if our team lead can.
Yeah, I mean, the frequency exemption is a statutory exemption, so it applies irrespective of the decision making this evening. But yeah, the statutory exemption will apply notwithstanding.
Any more questions from members? Okay, so I just got two just to clarify something and put it on record. So we've got this before us, which I'm assuming, but just to confirm that it means that at 4.4, there are none of the mandatory grounds for refusal are triggered by the applicant.
That's correct, yeah. The officers will make the decision on mandatory grounds, and we would disqualify an application if any of those applied, yeah.
And then in terms of the public sector equality duty, that public sector equality duty is that we have to think about how an application would affect the people in the town and people around the area with those protected characteristics, and show that we've thought about it, but it isn't. It doesn't sort of prescribe any particular outcome. It just requires the committee to show that we've considered it and thought about it and its impact. Is that my understanding correct?
Yes, although I would say this is not a tick box exercise. I think the committee does need to wrestle with the public sector equality duty with meaning. So yeah, it's and the duties are outlined at 6.1 and those protected characteristics which applies in this application at 6.2. So for the committee, this is not a tick box exercise. You need to wrestle and address this with purpose in your decision making process.
Thank you. I'll just check there's no more questions. Can I just check with Democratic Services, have we got the names of the speakers for the applicant already? Yeah. No, sorry, for the applicant, as in the representatives, not the objectors. Yeah. Yeah. Okay. Rather than getting you to give your names for the minutes, if they're already there, then that's fine. So.
It might just be helpful for the other parties to know who they're talking.
Okay. Yeah, that's probably useful. So, if I can ask the applicant whether you've got any questions for the licensing officer based on the report, and if you can just introduce yourself when you first speak, please.
Sir, thank you. Good evening. My name is Leo Charalambides. I'm the barrister representing the applicant. We have no questions. It was a very helpful report. Thank you very much.
Thank you very much. Now we've got to reference the objectors by number because of, and actually those speaking in support, just because of the way the law's written. So I don't know what order people are sat in. Are they sat in the order going round? Or? No. Okay. So this is just whether there are any questions for the officer. Okay. So.
I just wanted to follow on from an exchange that I had with the licensing team yesterday regarding I believe the apparent admission of additional evidence, a disclosure that we received at lunchtime yesterday. It was really just to follow on from my request yesterday to raise concerns that, my understanding is that this process should be taken when all parties to the hearing have had an appropriate amount of time to review the evidence. Bar a cursory glance, none of us have been able to review the disclosure that was sent to us yesterday. The applicant has had a significant amount of time to prepare for this hearing, and I believe it's fundamentally unfair for this evidence to be admitted into the hearing. And as I requested yesterday, I would ask that the committee consider adjourning this meeting so that we have a chance to review, absorb and respond to the information appropriately.
So I'll ask the licensing officer to just respond to that and then give the applicant.
I just want to check a legal point with Vicky as well.
Okay.
I just the conversation was just really around a slight technical point in that the 28-day consultation period obviously happened, and the question around based on the bundle, whether the objectors can change or bring in new representations outside of the 28 days based on the bundle that was distributed. I think from the authority's point of view, it's clearly the applicant complied with our requirements in that our probity guide, our constitution, says 2 clear working days. It was submitted on Monday, although obviously overnight officers didn't get it until the following day, but it was submitted within our requirements. I think, and we will have the applicant will obviously be able to respond to the response as well, just in the interest of fairness. But I think from an authority point of view, I think it would be perverse for us to defer a hearing based on them complying with our own requirements. So clearly it will be a committee debate, and the committee will have to take a view on this, not an officer view. The committee will have to take a view and a vote on that. But I think that's the officer's position. And I don't know if the chair wants to also give the applicant a point of response.
Yeah, thank you. Certainly, I think the applicant's entitled to response to that.
Sir, thank you. As I'm sure your legal advisor will have let you know, this is an administrative hearing, so the normal rules of evidence don't apply. There is no appropriate process in that way. Though, in effect, what you've got is an application that we've made. We've sat back and waited for civil society to comment, which they have done. So it naturally follows that we've responded to that, and we've responded to that within your timeframes. As you were reminded by your officer a moment ago, we get the last word. So if you were to adjourn, you'd find yourself in a bizarre situation where we would then have whatever comments they make, if any, we would then respond to them within your time frame, and they would still have some 28 to 48 hours to respond. In any event, your officer will have, your legal advisor will have informed you that hearings are not, strictly speaking, covered by the schedule itself. Objectors aren't invited to speak. You're only legal authorities that have regard to their written representations. So the fact that they're here, the fact that they're engaged, the fact that they're speaking already ensures that their Article 6 rights are covered. It would be a dreadful waste of council resources and everyone else's time for us to adjourn. And of course, the most important people that have to read it are yourselves. You don't want to hear us arguing because there's no cross-examination. You want to know that you've read our application, you've read our responses, and you've read what the objectors have to say and what they'll say this evening. And so it's entirely compliant, and adjournment would be wholly inappropriate in these circumstances. Thank you.
Thank you. From my perspective, it arrived in my inbox, and it's not excessively long. I was able to read it. It's not particularly impenetrable, so I'm not. My personal view is I'm not minded to adjourn, but I will look to my colleagues to see if there's any further comments. Councillor Wheeler.
Again, as a retired person, I've had plenty of time to go through this and read it, even though I'm quite a slow reader.
Councillor Steinhardt?
Yes, I did find that some of the information given in that bundle was also in the report. So in fact, it wasn't as long. And again, being retired, I had plenty of time, but actually it didn't take very long to read.
Any more comments?
Yeah, I mean, I work and I was actually at work till 10 o'clock last night and I probably didn't see it till about 4 o'clock, but I still managed to, it isn't long and I don't think it's a major consideration.
Yes, just the same as colleagues. I work full time and was at a meeting last night and I still had a chance to read it.
So I think we'll just do the show of hands, but I think that we're unanimous that we continue to proceed. Are we all agreed? Yeah. Okay. So we have all had an opportunity to read it. So we're happy to proceed. We don't think that it is unfair, and given the comments that everybody is actually here, I think that's it's quite reasonable for us to proceed. So are there any further questions from the objectors in response to the report? I am not seeing any hands. Okay. So we have 6 speakers who wish to speak against the application. I think we had 2 supporters registered, but I think one has withdrawn. So we will refer to speakers by number, which is where it is in the published documents. And firstly, your verbal representations are to expand on and clarify your written representations. It's not an opportunity to seek to introduce new evidence, as the applicant won't have had any opportunity to review it, and that violates their right to a fair hearing. Secondly, while people might disagree on matters, I'd ask everybody to treat each other with courtesy and respect, specifically using non-pejorative language, such as premises to describe a location, SEV or licensable activity to describe what's being licensed, applicant, performer, dancer, employee to describe people who work there in various capacities. It's just polite to everybody to use that sort of language, whether you're speaking in favour or against. So if I can first ask representation number 35 to address the committee, please.
That's me. So licences issued for SUVs in Cheltenham contain conditions 18 and 25 prohibiting touching between performers and between performers and customers. These conditions are widely acknowledged as essential for the good regulation of lap dancing and to protect both the performer and customer. During March Race Week, touching between performers and between performers and customers was observed on multiple visits by the police and council officials at Under the Prom. I understand that police issued a written warning to the licence holder. Touching was also observed at Moo. No breaches of touching conditions were identified during inspections of Cambray Place. However, as the applicant is also the licence holder for Under the Prom, it is relevant and reasonable for concerns to be raised in relation to the operation of this venue. There is extensive publicly available evidence that touching occurs in SUVs across the UK. With touching observed at 2 of the 3 SUVs operating in Cheltenham, it's evident this reflects the wider national picture rather than being the exception Cheltenham is presented as. A variation to condition 25 has been requested. Initially in the application, it appeared to ask that movement indicating sexual activity or simulated sex between performers outside of the performance area be permitted, but it now appears to have been amended to any movement that indicates sexual activity or simulated sex between performers or entertainers is strictly forbidden. In condition 25 of the council's SEV policy prohibits any bodily contact. Given the breaches that occurred in March at the applicant's other venue, this request is concerning. And based on the information provided, it doesn't appear that there is any exceptional circumstance to support a deviation from the policy condition. The current licence stipulates that signs on the building are erected and removed within 20 minutes of opening and closing. I understand that following a complaint made during March race week, the applicant was corresponded with under caution regarding a potential breach of this condition, and signs on the pavement and building were observed to have been erected up to 60 minutes before opening. The previous licensing officer advised that the signage on the pavement and A board is not covered by this condition but would need permission under the Highways Act 1980. He confirmed it was his understanding that such permission had not been requested at the time it was displayed in March. The application requests that the special condition is amended to an hour rather than 20 minutes. The special condition under review was agreed at the last hearing as a compromise, given the sensitive nature of the area the venue is located in. The applicant confirmed at that time the condition could be complied with. Again, there are no exceptional circumstances that justify agreement of this deviation. In relation to opening hours for this venue have been amended from 6 p.m. from 8 p.m. for various dates in March, apparently on the basis of a recommendation by police around crime and disorder, and that this has been discussed and agreed with the council. The council under FOI have confirmed that neither they or the police can find any evidence of this recommendation being made by the police or discussed during any meetings. And the council maintain that such a recommendation has not been made since at least 2021. There are a number of venues where members of the public congregate outside in Cheltenham, and I'm not aware that this creates issues in relation to crime disorder to such an extent that hours of operation are changed. Point 7.5 in the report from the Head of Public Protection advises that in relation to requests to vary the standard SUV licensing conditions, the committee must not arbitrarily deviate from its own licensing policy. Where the committee consider there to be exceptional circumstances that may justify a deviation from its licensing policy, these must be thoroughly reasoned and recorded. I would suggest that any such exceptional circumstance does not exist for any of the variations requested. If the committee elect to issue this licence, I would ask that the licence conditions are amended to include the following. Performances in booths are not permitted as it's evident that licence conditions prohibiting touching are not being complied with, that the opening hours revert to 8 p.m. as outlined in the council's SUV policy, and that the condition in relation to signage is amended to reflect that it applies to all signage on or in the vicinity of the premises, and that the variation requests in relation to condition 25 and the special condition in relation to signage are refused.
Thank you. Are there any questions for the speaker from the committee? Right, I am not seeing any questions. So from that point, can we move to speaker number 46, please?
That's me. So I'm here speaking on behalf of Gloucestershire Rape and Sexual Abuse Centre, GRASAC. I first wish to address the page 11 of the document that we were sent yesterday, which was referred to earlier. GRASAC is referenced in that document as distributing material with the applicant for the safety of people working in the venue. I just want to be absolutely clear that in doing that, GRASAC is not condoning the activity happening at that venue as a sexual entertainment venue, but our primary concern is always the safety of women and girls. So that was the reason for that. And we object to the suggestion through this document that we are condoning the activity. Then further to that, so following our online submission in September, I just want to draw your attention to the link between the national picture of violence against women and girls, VAUG, and specifically instances of rape and sexual violence, including sexual harassment and sexual entertainment venues. So you're probably all aware that in 2021, the council's research found that 75% of women in Cheltenham feel unsafe in and around the town during race weeks. This associated behavioural change means that whilst women working in the venue may feel safe to work, local women are telling us that they don't feel safe enough to conduct their day-to-day life during race week. And this in itself is unequitable. The larger number of women don't feel safe in Cheltenham during race week. So where does this sit within the public sector equality duty? I'm sure you're all aware that Maggie Blythe is now our interim Chief Constable at Gloucestershire Police. Earlier this year, she described violence against women and girls as a national emergency and urged that we need to move forward as a society to make change. And there's an increasing number of cases around VAUG happening nationally. And I'm sure we can all agree Cheltenham is no exemption to the national picture. So the link between this national emergency and sexual entertainment venues in Cheltenham is supported by two studies which clearly identify a link between sexual entertainment venues and the behaviour that leads to violence against women and girls. So men who view women as sex objects had attitudes more supportive of violence against women. And a 2021 study of over 10,000 men stated that the second most frequently reported motivation of men who admitted to rape is relating to entertainment seeking and interpreting forced sexual access to women's bodies as fun or something to alleviate boredom, which is, I would suggest, the reason why sexual entertainment venues exist. It's entertaining. The name is in the venue title. So the link is shown in these studies between sexual entertainment venues and violence against women and girls. These venues give permission for customers to see the performers as objects, and violence against women and girls, specifically instances of rape and sexual violence, including sexual harassment, the link is clear. So by approving the licence variations requested on this occasion, where is the council putting Cheltenham in this national violence against women and girls emergency? And how seriously is the council taking the concerns about safety raised by local women answered in the council's own 2021 survey?
Thank you. Are there any questions for the speaker? Okay. So I've got one for you, which is you've obviously quoted from the council's own survey. The outside of Race Week, the figure for the number of women that felt unsafe was not particularly much lower. There was still a lot of women who felt unsafe. So how do you know, Race Week has got a lot of people who are here who have consumed quite a lot of alcohol, who've not gone anywhere near an SEV. So how does that small change, how do you link that to the applicant and the activity?
So my point was around the studies which cite sexual entertainment venues as, you know, driving this behaviour and attitudes in men that lead to violence against women and girls. So the fact that that many women already feel unsafe in Cheltenham during Race Week, then the link between those venues and the behaviour, how does it help people feel safer to, especially given the licensing changes that are being requested?
Thank you. Are there any more questions? Okay. So if I can now ask speaker number 59, please.
Thank you, Mr. Chair. I'm one of the trustees and elders of Cambray Baptist Church, and so I represent over 270 adults and 100 children and young people who regularly attend and worship in Cambray Baptist Church, as well as the hundreds of others who meet in and around the church building each week. I realise that the ladies and gentlemen of the committee have a difficult task with many competing concerns to balance, and so I thank you for the opportunity to speak to you this evening. It is with sadness that we are in this situation yet again. Once again, we are having to express our profound and ongoing hurt at the council's decision to permit an adult entertainment venue immediately opposite a thriving city centre place of worship, which is counter to guidelines that explicitly make allowance for the council so it can fulfil its duties to protect the freedom of belief and worship of those within the town. Once again, we find ourselves fighting for marriage, for the strengthening of relationships and for secure home life when faced opposite the church with an activity designated or designed to undermine the sanctity of marriage and the integrity of family life. Once again, we find ourselves seeking to run activities for children, youth and families when opposite us, we face an activity which is both wholly inappropriate to these events and makes the area appear to be a no-go area for families in the evenings. Once again, we find ourselves upholding the intrinsic creation value of women and seeking to help those who have been victims of inappropriate behaviour towards them, when immediately opposite is a venue that encourages men to view women as objects rather than as deeply honoured individuals, valued for who they are as a whole person and not merely as providers of gratification. Once again, we find ourselves treated as unequal citizens in the town we have served faithfully for over 180 years, even while we continue to care for the outcast, the lonely, the needy and the poor, all at our own cost, without recourse to funding from other sources. Our written submission gives clear, valid and actionable reasons why you can, without challenge, use your discretionary powers given in section 4.5d, 1 to 2, and 410a to d, to refuse this and any future application. You have strong legal grounds for discretionary decision to turn down this application. We acknowledge that a decision to refuse permission would require bravery, fortitude and determination, but this is at the heart of what it means to be a councillor. Members of the Licensing Committee, you have the opportunity tonight to make a momentous decision for the good of the town we love and to serve so wholeheartedly. We trust that you will tonight turn from your scripted responses in a bold new direction as other councils have done. We trust that you will start a new narrative in this town, one which recognises that the decisions you make really can set a new agenda, send a new message and bring out hope in this town. Thank you, Mr. Chair.
Thank you very much. Are there any questions for the speaker? Councillor Steinhardt.
This is just, thank you for your presentation. This is just a practical question on timing and what sort of timings do your clubs, etc., have during the week, and how do they compare with the timing that is put into the SEV?
Thank you for the question. Anywhere between 5 and 6 and also between 7 p.m. and 9 p.m. on more than one evening during the week. Thank you.
Thanks. Can I just check the information on your website is correct? So when I looked at the events, and there do seem to be events for children, all of those events say in the access arrangements for them, entrance on Rodney Road or entrance via Rodney Road, Essex Place side entrance. So there would be no need for anyone to go past the SEV to access, as your own guidance says.
Thank you for the question. Some people do access the Rodney Road end of the church via the front of the church, which is from Canberra Place. So it's not always accessed solely from the Rodney Road end, if that makes sense. Thank you.
Okay. Councillor Wheeler.
Yes, just for that, Chair, and maybe this is not a relevant question that I should be asking, but for those people who are accessing from Canberra, can you explain to me the dangers that they may be seeing? You know, the applicant has been told he's not allowed to have advertising out the front there, though there was mention that there was some previously, but I think we can address that separately. Are there activities that people accessing via Cambry would hear or witness in any way, shape or form? Because if there is, then maybe we can find some way of addressing that.
I can imagine a situation where people coming to the church from the front, if they see the clients and the clientele, they would, see what's happening, and that would sort of be a factor in our objection to the application.
How would that differ from its use as a drinking club or any other type of venue? Is there anything obvious that you see that says this is a sexual entertainment venue that people would obviously see or hear?
I think I've just said all I need to say really on that, so I'd rather not comment any further. Thank you.
Okay. Any further questions? Okay. Where were we? Okay. Representation number 60, please.
Right. So, as discussed in previous meetings, I understand and I believe the government needs to update the law on sexual entertainment venues. And until that happens, the council's only options are to lobby the government for change. Thank you for sending that letter. Issue these licences and enforce licensing standards. I'm here to ask the council to enforce these standards and to speak against the request from the applicant to have these standards changed. They were introduced in response to the council's own 2020 Community Impact Assessment. This says the council is aware that females in particular feel disadvantaged by the sexual entertainment and licensing of SEVs. This is manifested in both a general sense of feeling objectified and more specifically through feeling intimidated and unwelcome in the vicinity of licensed SEVs. To reduce this disadvantage, the council introduced a number of SEV licence conditions, including Policy Standard 6 about advertising, solicitation and displays. This states there should not be displayed any adverts and there should not be any personal solicitation of people. There shouldn't be any leafleting. There shouldn't be cruising vehicles. The applicant has asked that all these be changed. They've asked that they be allowed to solicit individuals to attend the premises during the hours the licence is in operation, provided that no solicitation takes place to anyone who appears to be under the age of 25. This is perhaps something that people going past Cambray Place might see. They're also saying the applicant's also asking to operate a courtesy vehicle to transport dancers and clientele, and to be allowed to advertise, including by way of leaflets, this courtesy vehicle at all times during the permitted licensing hours. Now, we know the leaflets are very simple. They've just got Eurocats and the phone number, but let's not be naive here. Google exists. It's pretty clear what is being advertised. And this is kind of a question, kind of a statement, but the documents provided by the applicant imply that performers don't make that much use of the courtesy vehicle. And so I am curious about what proportion of performers use the courtesy vehicle to get home after a shift. And basically, I am asking the council to reject this variation. Permitting solicitation, cruising vehicle and leafleting means the council is placing the needs of the operators of sexual entertainment venues above those of Cheltenham residents, especially women and girls.
Thank you. Are there any questions from the committee? Councillor Wheeler.
I think this would come more from officers, and maybe I've missed something insofar the I mean, we've heard about the taxi service, and we've discussed this before. Advertising and leaflets. Is there anything that's obvious within the leafleting that we need to be concerned about?
So it's worth saying that there's a separate licensing or permitting regime for distribution of leaflets. So subject to whatever the committee decides today, the applicant will be required to apply for a separate permit under the Environment Protection Act for the distribution of free printed matter. And so there's a different set of standards that applies to what the council would accept. So it can't be offensive, it can't be racist, it must comply with the Advertising Standards Authority's rules and things. So the content of the leaflets would need to comply with the separate permitting regime. But to date, because we've issued a permit for the distribution of free print matter, we've had no concerns about the content, as the objector said. They're fairly basic in terms of face value.
Thank you. Any further questions? Okay. So if I can ask speaker representation number 45, please. No. If not, well, I'll tell you what, while we're working that one out, which one is, who's 45? Ah, okay. So,
Give me 2 seconds.
sorry. Yeah, I think with the number of objections, it's proving a little bit difficult to make sure everyone is anonymised as required by law, but also that they can speak and we can work out what's doing that. And I think for subsequent applications, we'll try and make this a bit smoother, I think. Yeah, speaker number 45, please.
Whilst I want to recognise and offer my respect to Stephen for pursuing an application for the licensing for the SEV on Cambray Place, rather than pursuing this venture unregulated, I want to oppose this application on the following grounds. Speaking as a mother, a woman, a children's worker at Cambray Baptist Church, and as a Christian, I am also speaking on behalf of the many children and young people of Cheltenham that are unable to be here to represent themselves. I oppose the proposed application for renewal of the licensing for the SEV on Cambray Place. The genre of this business has encouraged clients to its venue, bringing disruption requiring police intervention. During the consultation of the licensing application for the same venue for this current year, concerns were raised over the safety and perception of this area of Cheltenham, particularly but not limited to that of women, children and youth living in and visiting this area. The antisocial behaviour occurring early in the evening was witnessed by children, youth and parents as they were arriving and leaving Cambray Baptist Church clubs and many others in the area at the time, which only realised and provided evidence-based concerns that have been previously raised and subsequently dismissed in favour of approving the requested licensing application by Red Apple. It remains unacceptable to continue to subject women, children, youth and the local community to this potential unwanted offending behaviour and social unrest. In the documentation for this application, an excerpt from the Cheltenham Borough profile indicates 45% are Christian and the largest proportion of all the religious and non-religious groups representing our local community. The nature of the SEV business brings further offence to, but not limited to, a number of faith-based communities in Cheltenham town centre. It is offensive as this type of venue continues to fuel the ideology that women are merely objects and impacts the safety of both women and girls. I recognise that many women choose of their own free will to work in this business. I fully support that women should have freedom of choice. However, what the Christian faith chooses to promote and offer is that women are uniquely and wonderfully made and not a pure object to be bought or of lust. This business only continues to promote the opposite and devalues women and girls. There is a great concern in the community regarding the safety of women and other vulnerable groups. It is evidence that there is an increased perception that women feel unsafe in Cheltenham at night, particularly during race week. I would urge the committee to ensure that the vulnerable groups of the community are supported and protected by rejecting the request to renew this licence application. Whilst some support to this application states this is due to the rules and regulations in place to ensure staff and public are kept safe. These were clearly broken and in breach of the licence conditions 18 and 25 on a number of occasions during March 2024. Therefore, having a licence in place appears to have not prevented inappropriate behaviour towards staff. The evidence of this behaviour continues to be of offence to the number of faith-based groups in the local communities that neighbour this venue. It is possible for the community and those visiting Cheltenham to enjoy local events such as the Cheltenham races without the need for venues such as the Red Apple SEV. And therefore, again, I stressed to the committee to strongly consider rejecting this application for the reasons I've outlined, to have the strength of character to recognise how vital it is to the community I belong to, located directly opposite the Red Apple venue, and the legal rights to the freedom of offence in worship and belief, to enable the women, children and youth of our community to feel safe, protected and supported by their local council in this matter. I want to wish Stephen every success in all other areas of his business, precluding the SEV. Thank you for your consideration.
Thank you. Are there any questions?
So I wanted to know, what was the evidence that you've got that the observed antisocial behaviour relates to the sexual entertainment venue rather than just race week as a whole? I mean, as a woman in town, it can feel unsafe in race week, but that's largely, I feel, and I'm asking you, is that really the presence of the SEV or the presence of the large number of racegoers who may be intoxicated and are by and large male and maybe behaving in an antisocial manner?
It was witnessed by, as I stated, it was witnessed by children, parents and youth that were visiting the church premises, and these were clients directly from the SEV venue.
Okay. You said that you have a right, I've got it correct, to be free from offence in what you do. I'm just trying to work out where that comes from, because as far as I'm aware, freedom of speech and freedom of expression includes freedom to offend. So I'm just trying to understand where that's coming from. If you can explain what you mean to be free from offence.
So, as part of our Christian faith, as I've clearly stated in my statement, we have our views, and by the acts that are taking place in the venue opposite, that clearly is in opposition to that, and it does cause offence, and therefore we should be able to have the ability and freedom to be able to express our faith and to study our faith, and to not have to witness something that is in opposition to that, directly opposite the location in which we have the opportunity to do so.
Thank you. Any further questions? Councillor Sankey, then Councillor Wheeler.
Thank you. I just wanted to clarify, you talked about an incident that was witnessed by parents, youths, children. Were the police involved in this?
Yes, the police were involved. They were called, yes.
Yes. Can I start by saying that the business we're looking at this evening, the application, is not a business with that I'll be frequenting anytime soon, and never have done. Having said that, one of the things that was made very clear to us by officer, and we've been told many times, is that we're not allowed to judge this on moral grounds. Your statement said to me very loudly that your grounds were on a moral basis, so we can't take that into consideration, much as some of us may wish to. Can you highlight the bits of your statement that you would object to, but not those that are of a moral? I mean, if it's going on within the building, you may not like it, I may not like it, but it's going on within the building, and therefore any judgment on that would be moral. My concern would be what's going on that people in the general public who are not interested in what happens within the building, what will they witness? What will they hear? What would they even find offensive? For instance, fighting in the street, yes, if it could be proved to be there. Doormen trying to encourage people to come in from outside, people that have got no interest in going. That's the sort of thing I'm looking for, that I would find objectionable. But your religious beliefs about what's going on, that's getting very to...
Simon, Councillor Wheeler, you probably want to get to a question.
Yes, my question was, what part of your statement was not based on morality? Because we can't take that into consideration, much as we may want to.
So my statement still stands on the basis of my Christian belief. That is not moral. It is
my Christian belief, and I have no further comment.
Okay. Any further questions? Okay. And finally, if I can ask speaker number 96, please.
I'm going to read out a statement on behalf of the members of Gloucestershire Women's Liberation Collective. Gloucestershire Women's Liberation Collective would like to thank the Licensing Committee for the opportunity to contribute to this evening's meeting. We object to the application made by Red Apple Associates Limited, trading as Erotic Acts, to renew and vary their existing sexual entertainment venue licence to allow for stripping at Jessup House to coincide with race meets at Cheltenham Racecourse throughout the year. We note that our letter was one of a large number of objections expressing concern about the negative impact that SEVs have on the lives of women and girls in Cheltenham. It seems clear that there is significant concern amongst the public. More and more people are joining the dots between the sexual objectification and commodification of women, which underpins the sex trade, the sexist and misogynistic attitudes that permeate society, and the endemic abuse and harassment of women and girls. In the time that we have engaged in the SEV licensing process, we have been disappointed that the committee has not given detailed consideration as part of their public sector equality duty to the broader sex-based equality concerns repeatedly raised by objectors. We would remind the committee that it must give due regard to all three equality objectives in its decision-making, and we would argue that there is more than sufficient evidence. We have referenced a number of different papers and reports in our most recent and our previous submissions to require the committee's consideration to encompass not just equality issues relating to the operation of the strip club, but also in respect of how the strip club impacts the wider community in Cheltenham, particularly women and girls. Strip and lap dancing clubs where women are sexually objectified and the idea that men are entitled to access women's bodies is reinforced, where that is reinforced, contribute to harmful, sexist and misogynistic attitudes that underpin the endemic abuse, harassment and violence against women and girls in society. This is a situation which the National Police Chiefs Council has now described as a national emergency. Cheltenham is not immune to these issues. Plan International's recent The State of Girls' Rights in the UK report made for bleak reading. For girls and women and young women in Cheltenham, violence and harassment is a particular issue, and the most recent Cheltenham Borough Council safety survey highlighted that only 5% of respondents felt very safe, with around 68% of respondents feeling not very safe in Cheltenham during race week. Breaches of SEV policy standard conditions in respect of touching, both between performers and between customers and performers, were identified during inspections at a different venue operated by the applicant during Race Week 2024. We are concerned that despite reassurances given by the applicant that performance areas are constantly monitored by booth walkers, breaches of licensing conditions have occurred that may have harmed women performing in the venue and increased risk for other women working there. We're also concerned about the implications that these breaches of conditions may have for women and girls outside the club. We're extremely concerned, given the breaches that occurred in March, that the applicant has requested a variation to Standard Condition 25. The initial amendment suggested that the applicant might be seeking permission for women working in the club to make bodily contact and or simulate sexual acts in non-performance areas. It now appears that the requested variation has been amended to the following wording: any movement that indicates sexual activity or simulated sex between entertainers or performers is strictly forbidden. This change seems to suggest that the applicant is now seeking permission for women working in the club to be able to make bodily contact, which Standard Condition 25 prohibits. Within the applicant's disclosures, it is intimated that this change has been discussed with the police and licensing team, but no details of this discussion or the rationale for this change have been provided, other than to state that the change is to better regulate the nature of the performance. No detail is given as to whether this change would be limited to performance areas or not. Our concern that this variation could put women performing in the venue at an increased risk of harassment and or assault remains. If a SEV licence is granted, we would ask that this variation of the standard conditions is not permitted. Additionally, we would ask that performances in booths are not permitted to ensure that performance areas can be better supervised. More generally, we would ask that the safety of women working in the strip club, as well as women and girls in the wider community, is prioritised and the committee applies the SEV policy standard conditions without variation. We were disappointed to see that the committee's recent letter to the Home Secretary fell short of asking the government to take action to repeal the frequency exemption, despite the committee's stated position that the ability to add enforceable conditions to an SEV licence makes licensing more desirable than use of the exemption, as the ability to add conditions is preferable for the safety of performers, customers and the public. We note that the committee recognises that the existence of the frequency exemption has led to the creation of exploitable loopholes. We hope the committee has listened to the negative feedback about use of the frequency exemption during race weeks, and that the committee recognises the effect that the frequency exemption's continued operation has in undermining the exercise of local democracy. We urge the committee to listen to the voices of women and girls and show a commitment to their public sector equality duty in deciding the outcome of this application.
Thank you. Are there any questions from the committee?
Yeah, I wanted to ask whether your objections would be the same if the performers were male or transgender rather than female, assumed, and or whether the audience was the likely audience was primarily female rather than likely male, because I mean, otherwise we're not on an equality ground.
I'm sort of making the point with the objection that this is a business, the operation of this particular business is mainly, there are women working in that club, and it is mainly marketed and to male clients. We've also seen within the pack of information that the applicant provides that there's a poster or a leaflet, I don't know exactly how this is displayed, that talks about gentlemen, and that they are encouraged to treat the female performers with respect. So our objection is very much focused on this, you know, what is presented to us in terms of this application for this application and then this applicant and the nature of this business. And so we are looking at that in the context of a national emergency in terms of violence against women and girls. And there is significant evidence about the link between, you know, harmful attitudes that the sex trade really does kind of underpin and promote, and how that links to violence. So, you know, that's our position.
Any further questions? Okay. So I've got one just firstly on the public sector equality duty. So a lot of the majority of the performers who work there are female. So how do you sort of see the fact that there are women who clearly want to work there, and how do we square the circle where we have the group with the same protected characteristics saying we don't want this happening, and people who are working there? Because it feels to me that we're put in a very difficult position of public sector equality duty of having people with the same protected characteristics saying different things.
Yes, because women don't all hold the same views and should be free to conduct their lives in the ways that they choose. You know, so we totally respect women's choice to perform in the club. What we're trying to sort of highlight, we're trying to kind of zoom out really and look at sort of, you know, the impact on women and girls as a sex class as a whole, and you could zoom out globally and see that we have a huge issue with attitudes towards women and girls. So we absolutely respect women's choice to perform in the club, but we're saying, you know, when we look at women and girls as a sex class, we've got a massive issue and we need to take action to tackle this.
Thank you. And the second question I've got, so obviously you mentioned the comments about the frequency exemption. In terms of safety of women in general, do you think things would be safer if it's in a licensed venue with an SEV, or if it's operating under the frequency exemption? Which of the two do you think would be safer for women?
I think that's a tricky question, actually, because we've had breaches with the licensing regime, and we know that there have been breaches under the frequency exemption. I don't, I don't think there's a really safe way of allowing this activity to operate. I would hope that anybody operating under the frequency exemption would work very closely with the council to adhere to the guidance. I know you have sort of guidelines that you would hope that operators would work towards, but I just don't feel there is a very safe way to operate this kind of business because of the potential impact and the risks to the women working in the club, but also the wider impact on women and girls in the community.
Thank you. Any further questions? Okay, so we now need to move to the supporters, and I think there might be a pause. Will there be a pause while we make sure that people can't be seen? Okay, so if I can ask person who made representation number 8, please, your turn to speak.
Hi, so I have worked for Rockcats from the beginning, so it's about almost 13 years, I think now, as a performer for about 5 years before I took my current role, which is senior house mother. My role within the operation includes, but is not limited to, ensuring all performers are safe and comfortable from start to finish, making sure that every performer and staff member knows the procedure, the layout, the rules of the event, being available for any advice, guidance for solving issues that the performers might have. This is something I take really seriously and I'm very passionate about. I work alongside an excellent team of security staff and other members of staff as well. I would like to emphasise the importance of licensed venues because I have worked in over 30 over the course of about a decade. And Rockcats, without a doubt, is the most slick, well-run operation I've ever encountered. If I did not wholeheartedly believe this business to be safe and fair, I would not be here today. I've encountered a lot of questionable practices over the years, and we just want to make sure that everyone has a positive experience from start to finish. We have performers and customers that return year after year. That's a credit to the management and the execution of the events. So on the subject of safety, I genuinely feel unsafe as a woman in Cheltenham anyway. I do, that's facts. That's not obviously a Rockcats problem, that's a society problem in general. We spend about 2 to 4 hours at the end of shifts getting people to cars, taxis. We don't let them walk anywhere. Obviously, they're adults. We can't stop people leaving the venue, but we find a solution where we can to get anyone where they need to go, including customers sometimes, actually. The bus is definitely used. I'm not lying there. If you stand outside, you'll see me shouting at people, getting them in the bus all night. It's integral to the safety, and that would mean I'd have to pay for taxis home, so I don't want to get rid of that. If not granted, it's inevitable there will be other events that pop up from other people, which will be badly run. Undoubtedly, to grant this licence means we've got a regular, safe, structured premises to work that's regulated by the laws and conditions that I welcome. As long as this activity remains legal and the company continues to operate in a safe and fair manner, I will support any licence that it applies for. Thank you.
Thank you. Are there any questions? Councillor Steinholt.
Just a query about your position and training and knowledge of legislation. Do you have a specific training schedule?
No, I'm not sort of representing them. I'm doing this off my own back from the performer's point of view. I've got no legal training. I read everything that you guys obviously provide during this consultation, so I've got a good idea and understand other people's viewpoints. But no, I've got no training in that sense. It's because a houseman should be someone that's done the job. So to try and find someone from outside to do that or get someone else, so obviously when I was offered it, I was like, yeah, I can do some good there.
Councillor Wheeler.
I'm guessing most people here will know, but can you give us a brief summary of what your job is as a house mother? That's right.
So a houseman's basically just someone that's there between the owners and the other staff and the performers. So I deal with everything really. So when people arrive, we show them where they get changed, make sure they've got the right documentation, all that sort of thing. Show them around, tell them the rules, make sure that they've read the rules and everything like that. And just generally, so a lot of our performers come back time and time again, but when you've got new people, obviously just being there for them at the start and throughout the night, during the shift, generally just anything and everything, really. Getting people, if they need to go because they're not well or something's happened or that sort of thing, you know, everything and everything, really. And then at the end, making sure that everyone's cashed up, everyone's happy, everyone's getting home okay, making sure that, yeah, everyone knows where they're going and what they're doing.
Yes, and just very quickly, I mean, I did read the, from the additional notes, the very last, well, penultimate rules and regulations. And maybe this is a little unfair question, but is there anything that you feel should be added to that that would make things safer for the performers, for customers, and perhaps even for, or especially for maybe the general public? Is there anything you think you'd like to see added to that?
There's nothing I can think of. I get asked this one a lot, but we just continue to engage, really. We really appreciate, got a good relationship, I think, with the council when it comes to that sort of thing. So, no, nothing at this time.
Any more questions? So just one from me. Obviously, you said you've worked in different places. Have you worked under the frequency exemption as well as under licence, where a licensed venue? And can you give us an idea from a sort of performance point of view and a house mother's point of view, which one you feel is preferable?
I have worked at events that operate under an exemption, various different places, but it's always better to have a licence. If we don't have a licence, then if we were to operate under the exemption, it means having to really work extra hard to make sure everyone knows the layout and all of that, and that have to happen however many times. So it creates a lot more work, and I think it's better that, you know, when performers are there, they know what they're doing, where they're going, where to find me, where the exits are, all that sort of thing. To have to explain that over and over again could be quite long-winded. So yeah, licensed always.
Thank you. Right. Any further questions? Right. So we now move to hearing from the representatives from the applicant. But before I do that, I just want to check whether anyone needs a comfort break from the committee, because obviously we have to hear everything. And if anyone needs a stop, I'm not seeing any indications. So I think the time we spent with objectors was about 50 minutes. So I think we give you the same amount, that amount of time if you need that much. But I'll hand over to you, and there may well be questions from councillors afterwards.
Sir, thank you very much. Yes, I think it's been very helpful to hear from everyone. And as your officer pointed out in his presentation, what we have here is a strict legal regime, and the factors that you can take into account are the discretionary factors. So what you've also heard this evening, and I make no criticism of that, because of course members of the public are not lawyers, they're not council officers, they're not councillors, and so I would not expect them to speak as lawyers or councillors. But you've heard a lot of passionate feelings in respect of people's personal faiths, people's personal views, and I have to say, an assumption that certain individuals are somehow more qualified or in a better position because of their interests, education, religion, role, or whatever it may be, to speak for the good of the town. And of course, the good of the town seems to be allied with sort of personal religious beliefs rather than with the proper engagement with the regime. So the people that are able to make good decisions, lawful decisions for the good of the town are yourselves. The good of the town, of course, includes people with genuine religious beliefs. It includes the interests of people who to quote from the Jerry Springer opera, Just Want to Dance, for those of you that are familiar with that particular piece of musical offering that was at the Royal Opera House. In fact, if you followed the logical conclusion to some of the representations you've heard today, an opera at the Royal Opera House glorifying stripping would be so offensive to certain people's religious beliefs that we must ban it. And of course, that can't be right, and it can't be balanced. And that's key here. What you're trying to do is engage in a degree of balance. And the way you approach that balance is to look at the application. You're being asked to renew an application which has been operating at this particular premises for what is hoped to be its third year. But as an operator within the Borough Council, it's been operating since 2012. Now, I was interested to hear that a Freedom of Information request indicated that there's been no conversations between police and licensing and so on. That's just wrong as far as we're concerned. Back in 2021, it was observed that my client was operating quite lawfully and quite properly during race days under the exemption. This is an exemption that has been allowed by Parliament very specifically because at the time that the legislation was being amended in 2009, it was felt that pubs and miners' clubs and sort of institutions like that should be allowed to have lap dancing on the odd occasion. Hen do's and stag do's should be allowed to bring a nurse or a copper or whoever they might want to dress up, a Teletubby, if you will, at the venue and not be penalised for that, because we're adults. And adults understand that sexual entertainment is entertaining. In fact, sir, tonight at your town hall, you have, through your charitable arts organisations, invited the Dream Boys to perform. They are operating under the exemption. And in fact, if I go into your website, I'm promised the following: unadulterated pleasure. I'm invited to indulge in the Dream Boys being stripped back. I'm invited to have my desires come alive and my boundaries shattered and my inhibitions left at the door in your town hall. I've been shown a video where what happens is any one of the female audience members gets invited up on the stage and, well, to say there is touching and intimate touching would be an understatement. There is very little that her hands have not explored. So we recognise in Cheltenham that there is a balance and that some people may want to go into their churches and pray, judge their neighbour, and other people may want to go into their venues, close their doors and dance and entertain themselves. And that is perfectly legitimate. So because you didn't want people touching and fondling and engaging in unregulated behaviour, you invited, and when I say you, I don't mean you personally, but you, the council, in conversation with my client, invited us to pick a venue, stick at the venue, so that we can stay fully under your eye and indeed our neighbours. And we have done that at your request. And of course, now we're being criticised for that. It's also worth observing that we're not operating that much. We're probably not even as busy as the Cheltenham Town Hall, given the events that it hosts. 16 occasions a year, that's very close to the 11 exemptions. So what we're doing is we are sacrificing the freedom to operate in an unregulated way in order to engage with you and with civil society. I don't know how much Imogen costs, but I know I'm quite expensive. So, you know, we're putting our money where our mouth is, and we're investing in Cheltenham Borough Council. We're not doing anything secret or sordid or inappropriate. We're engaged in a lawful activity in a way that you have asked us to do. You can see, for example, that we've matched our application to the race days. We don't meet on a Sunday, and we operate in the evening. We operate and have operated from 6 p.m. During the week on the race days, and on Saturdays by 8 p.m. Because I think by that stage on a Saturday people are raced out, so it's not a very busy day. And it was discovered during the course of our operation that if we started at 6, it meant that the churn at these venues would be less obvious from the outside. I am fascinated what an SCV punter looks like, because apparently they're identifiable. I say they're not, because you've seen in the representations, they're people like us. They're the women that have filled your town hall today, seeing the Dream Boys. You've seen representations, actually 55 to 44, I think that's sort of similar to the American election, in favour of the SCVs, which include representations by men and women, adults visiting these venues together. So they attend in the evening during race days under this very limited capacity. So a very slight impact on your nighttime economy, which, by the way, you're looking to diversify. You don't want vertical drinking establishments. You do want a variety, and it may be that the Dream Boys aren't your cup of tea. It may be that the Eroticats aren't your cup of tea, in much the same way that some of us might like ballroom and others of us might like Morris dancing. There's a variety there. And even though you have a policy, your policy is not strictly applied. As was made clear by your licensing officer, it must meet the particular circumstances of the particular application. So these circumstances include timings, hours, and of course the conditions that we've asked to be varied. And the conditions are varied because of our experience of operating both as an exempt premises and as a regulated premises. The first and foremost is that there's quite strict conditions around advertising. And let's just pause here. It's advertising striptease, not advertising the venue. So if we look at the conditions very carefully, it's not really helpful to isolate just one condition on its own. Firstly, if you are, as I no doubt, I'm sure you are familiar with your policy, because I know you're in the process of reviewing it, so you're probably sick of reading it. But you can see there that under the standard conditions at Annex 1, what is not to be displayed is advertisements, photographs or images that indicate or suggest striptease type dancing taking place. There are rules about the handbill. There's references to the advertising standard agencies and whether or not they can be distributed. So what we've got confirmation from both your officer and the flyering regime is that indeed our advertising does not offend. It represents an appropriate compromise, a balance that one of the objectors referred to between these heartfelt but competing interests, so that you have a relatively innocuous flyer advertising a bus, not lap dancing. And in respect then of being allowed to use that courtesy vehicle, it's widely and generally acknowledged as a matter of licensing that SUVs tend to be quieter. If you think about it, the drinks are more expensive, the entertainment is more expensive. It tends to attract a certain clientele, and you get a view of that. And it's the kind of clientele that look for and are happy to use the bus. And so linked to the advertising on the bus is the use of the banner. We accept that back in March, the 20-minute window was just too tight. And so we just need an hour. It really is about practicalities. I'm not trying to change the world here or change Cheltenham. I'm just saying that we've got a banner that gets put on the narrow balcony of a building, which has to be put up before the event start, which is relatively easy, but then it has to be taken down at 4 or 5 in the morning. So we've got to get staff to perch on a narrow balcony, climb through a window, or use a ladder while dispersal is going on. There's nothing particularly exciting about licensing once you get to the nuts and bolts of it, because all becomes a bit health and safety, doesn't it? So any kind of sexiness or entertainment that you might have thought you'd have heard from me sort of falls away when we think about ladder slippages and heights of balconies. So what we're asking for is to just keep people safe. I can't imagine our good neighbours would want to imperil any of the members of staff putting up the banners and so on. So that is sort of very, very straightforward. And again, this no touch, the movement in the performance area, must be read in the context of an SEV. I know that many of you have visited this venue, not necessarily as patrons in case the press are here, but for the inspection of the premises. You know that there's open areas, there are bar areas. In fact, as you come in, there's an open public bar. To the right is on SEV days, there is a common room, if you will, where one of our speaker is generally found in order that the performers can be comfortable. The garden where the igloo is turned into a marquee that is used for the storage of the performers' equipment, outfits and so on. And then there are 3 distinct areas where the booths operate for the private dance. But without that private dance, what you have is a series of conditions regarding the performers themselves. They're noted on page 59. Those that are keenly sighted will have observed that they don't entirely replicate Appendix 1 because, of course, they've been amended to reflect the circumstances of the premises itself. But the relevant entertainment, the dance and or nudity happens in designated areas that are marked out, that are regulated, that are visible. You've heard references to our sort of walkers and watchers that are there at all time. Outside of those areas, the audience are required to be fully clothed. The conduct of the performers and their clothing is regulated in those areas. There's a reminder that the performances do not include any sexual acts with other performers, and the performances shall not include sexual acts with objects. So essentially, the condition that we're asking to be varied, which we've come to an agreement with the police, is about ensuring that there's no feigned or mimic sex acts in the performance. It's about regulating the nature of the performance itself. Those of you that visited the venue will know that the performance areas are long and narrow. The patron is seated at one end. There's a really good distance between the performer and the patron in order that they can merely view, which is what they're required to do. Essentially what we're asking for are minor items of housekeeping which reflect the regulatory concerns of your police and your licensing authorities. So really there is that. We're asking for a very modest but highly regulated opportunity for something we could probably do in any event. So there is that. If I can then turn to the discretionary grounds. Again, I'm very grateful to the generosity of one of the speakers that confirmed that there's no particular issue with the applicant himself, the sole director of Red Apple Associates Limited, Steve Burrows, and I'm grateful for that. I'm grateful for the witness statement from your officer from Cheltenham Safety. She's unable to be here this evening due to a family matter, but she took the time to make a representation, which is at page 101 of the bundle, and also provide a witness statement in order to present to you what she sees as the credentials and the dedication to the nighttime safety by Mr Burrows, something that no one has criticised. And of course, he is on many of your official bodies, which are directly concerned with everyone's safety and women's safety in the nighttime economy. It's about raising standards of licensed premises, of SEVs, and of all that operate there. You'll have observed in the representations that you've got representations from staff, one of whom has attended today, saying that they feel safe. It's a regulated environment. It's well run. There are representations from performers that say the same. There are representations from patrons that say the same. And now they have a distinct advantage over the objectors in that they've been in the premises. They work there, they perform there, and they enjoy themselves there. And they choose to go back, and some of them even choose to spend money there. And that suggests that this is a well-run, well-regulated, well-considered premises. I observe at pages 63, 100 and 108, 3 separate security companies have taken the time to comment on the safety of this premises and the way it works well. So given that there is only one applicant, only one director, the unsuitability grounds and the other benefit grounds really are met. There's no criticism on that. I then turn to the character of the locality. Well, you've deemed it suitable in a number of ways. Firstly, it's within your designated area. And now that designated area has changed and developed over the years. And tellingly, you have been quite happy to put the border so that it faces a pub and a church. Now, you've been well aware of the uses of this premises. It's been there for over 100 years, so I think the council might have noticed this church. And yet you've decided, as a matter of policy, that having an SEV facing such a venue would be appropriate. You've also decided that it would be appropriate to have such a venue there in 2022 and in 2023. What has changed? Well, the locations of the premises hasn't changed, the operation hasn't changed, the personalities haven't changed, the references in support haven't changed, so it behooves you to find something that has changed. And in the event that nothing has changed, your legal advisor will inform you that it would be inappropriate for you to make an inconsistent decision absent such change. And insofar as you might want some assistance in terms of assessing what the character of this locality might be. It's generally not a predetermined area. It's not the entire area of Cheltenham. I'd argue it's probably the opposite street and maybe just sort of the T-junction, if you will, the area of visibility. And there's something that, in the context of determining character of a locality, in the context of nuisance, I'm sure your legal advisor is familiar with Lord Newburger's speech in Coventry and Lawrence. There, in the Supreme Court, Lord Newburger told us that when we're looking at the character of the locality, we must take into account the established pattern of uses. And that's quite interesting because the established pattern of uses here includes a church, a pub, and a church that operate quite happily cheek by jowl, albeit that they all follow different moral, ethical, and practical applications, and so on. You're also in an area which has a purple flag. They've taken the time to write to you. So if you were so unsafe, if it was so inappropriate, are you cheating in getting your accreditation? I'd like to think not. And certainly knowing some of your officers for a long time, I don't think that's the case. When thinking about the locality, you must think of it both in terms of the time it applies, the season it applies. Something different happens to Cheltenham on a race day. I've never been. You're not selling Cheltenham to me, by the way. But race day sounds like a very different beast. It has a very different character. And so when we're thinking about the character of the locality, it clearly has an impact to visitors. It clearly has gambling and racing, also which are ethically and morally objectionable to some groups. It has drinking, it has entertainment, and it has SCVs. And it has had SCVs since at least 2012. We observe that the time, the duration and the frequency is limited. They operate outside of the hours of the church and the worship and so on. And I did note the slightly coy and may I say political answers rather than necessarily pious answers of declining to confirm that it's Rodney Road that is the main entrance. That's certainly our experience of Rodney Road. That's the main entrance for this sort of youth activities. Though interestingly enough, there's a studio that offers pole dancing every day, and there's a sign out there. So your community can learn to pole dance right next to the entrances on Rodney Road. I don't know how long it's been there. We've not been able to find that out. But again, another example of very diametrically opposed activities existing side by side in this area. And that really brings me to another key legal principle when we're thinking about the relevant locality, which was highlighted by the Supreme Court in the very recent decision of Fern and Tate. Again, another private nuisance case, but as we're thinking about suitability, I think it's apt. And that's reciprocity. You know, it's about good neighbourliness. So there's something that comes from a number of faiths, really. It's like, I'll let you pray and you let me party, in effect. But it's not holding one to a higher standard. And as the councillor very sort of appropriately questioned the committee, what can you see? What do they do? What do they look like? What impacts are there? And the fact is there are none. The police have made no representations, and they are, as we know, your experts in respect of crime and disorder, in respect of antisocial behaviour. And so as far as they're concerned, this is also a suitable locality. And there is no issue about the number because you only have one here. So I now turn to your public sector equality duty. I was sitting here thinking it's really quite useful that you're not under a duty to achieve results. Where do you even begin to, as you say, sir, square the circle? And that's recognised by the courts in regard to your public sector equality duty. You're to have an open mind, and you're to rigorously examine that. And it's been very helpful that, firstly, the objectors have brought their passions, and it's not easy to present them to public scrutiny, and it's certainly not easy to then have some Ponzi barrister comment upon them, and I'm sure it's very frustrating, so I apologise for that. But that's part of the scrutiny process and testing that. And we've also had someone speak in favour of these. But in terms of answering how do we square the circle, well, there are some things you can do. The first thing you can ask yourself is, insofar as we recognise that there are issues around inequality, that we have concerns about the safety of women and girls in specific venues, in our nighttime economy, and generally, though I'm not going to ask you to solve the problem both nationally and internationally, you can look to the venue. And you can say, well, what's the venue doing? Is it doing enough? And you ask the question of the house mother, is there anything further she could be doing or anything further that she would look for? And she says quite clearly, no, we've provided our policies for you. And in fact, our application is about women's safety because you have asked us to take on the added burden of regulation where we could quite profitably operate over 11 occasions across the race meets and do so very well. So in terms of thinking about, okay, well, what's this premises and the operator doing? Then you can say, yeah, they are doing something. They are having a positive impact because they are aware of it. You might then want to say, well, what are we doing as a council? Well, you've undertaken the study. You have an awareness of the impact. And it's really difficult to change perceptions and feelings. It's not comfortable as councillors, or indeed as operators of venues, to hear that women feel unwelcome in certain parts of their own town, though others do. So what can we do about that? Well, as I say, we've become transparent. We're making this application in public, under full scrutiny, and we're saying to you that the police have investigated our venue and they have no concerns. That might act to allay some fears. We say to you that our policies on the premises work. We say to you that the main applicant contributes to safety in the town. You're undertaking a review of your SCV policy. You undertake regular reviews of your licensing policy, at which the safety of women and girls is paramount. So you are doing something at a local level through civil society, the council, operators, and the police. And insofar as the national debate is concerned, and I do a lot of SCV applications, it's the first time I've seen a local authority, through its chair of licensing, write to the Home Office and say, look, we're in a quandary here. We recognise on one hand that there are impassioned views that want to ban lap dancing, and then there are other impassioned views that recognise a woman's freedom to choose. And we know these are not easy issues. I mean, we've seen across the Atlantic the way in which women's reproductive rights, for example, have become such a political issue, and they've riven a society apart. So similarly, you have taken the bold step to nationally engage with the Home Office. I can't think of anything more that you could be doing to demonstrate your understanding of the public sector equality duty, your commitment to having an open conversation. I don't admit this often, but none of us are right. All of our beliefs and passions are valid. However, you have two clear legal tests. One, are the discretionary grounds engaged? The clear answer is no. And then secondly, you have a duty to grapple with the public sector equality duty, which you're doing in a very public and informed way, which you've achieved. So yes, so in effect, I submit to you, sir, and to your colleagues, that this application is met. You are able to grant it with a clear conscience that we're going to be back next year for scrutiny again, which is one of the inherent safety features of these regimes. And secondly, we've had an adult, passionate, informed inquiry into the impacts of the public sector equality duty. No one has suggested anything useful to you other than shut them down because I don't like them. They've tried to suggest that somehow the hours should be limited, but again, those hours are agreed with the police. And there's been some issue around the booths. So I don't understand why you would interfere with Article 10 rights, or indeed Article 1 of the First Protocol, to micromanage the performance of a business that's not causing problems. I've heard no evidence of that, so I don't feel it's appropriate for me to address that. So, sir, obviously myself, Steve, my instructing solicitor are here to answer any questions you have, but I can wholeheartedly commend the application to you and look forward to you granting the application as requested with the amendments. Sir, thank you very much.
Thank you very much. Before I start questions, could I ask someone to grab me some water, please? Yes. Otherwise, I'm going to not be able to talk very well. So, do any of my colleagues have any questions? So again?
Just a point of clarification, and because I haven't been involved with sexual entertainment venues before, you've got the booths. At which end is the, because I think you've got a curtain at one end and presumably a wall at the other end and walls on either side. Which end is the performer versus the client normally?
That's what I thought. Thank you. That's a good question. I didn't know the answer either. The patron is at the wall end, and the performer is at the curtain. The curtain is see-through. You can see through it, and then there is a corridor that separates them. So there's someone walking up and down the whole time. So the performer is just able to leave if they need to, or indeed call for help.
Councillor Sankey.
Thank you. I just wanted to ask about the soliciting individuals outside. I just wondered where that would be, and I think it said you wouldn't do it to anybody that looked under 25, but I don't know about you. It's quite hard to tell who's 25 these days.
So the Challenge 25 is probably familiar to you. There's sort of lots of training available to staff in order to sort of challenge 25. If I can speak frankly, as I've been doing all evening, I suspect given the prices at SCVs, we tend to look for sort of older people anyway, because they tend to have deeper pockets. So that's the sort of practicalities of it. And in terms of the areas where there is leafleting, it's around the race area and the town centre, so broadly around your entertainment region. That's right, yeah.
Councillor Steinhardt.
Just again, a couple of practical questions, please. One is you're trying to vary the advertising schedule from 20 minutes to an hour, and you're putting up a banner of some kind on a balcony, which may or may not be difficult to get to in various guises. Why an hour rather than half an hour?
So it's just purely practical.
Microphone, sorry.
Steve.
Oh, sorry.
It's purely practical. Firstly, we don't want to say half an hour and then have neighbours upset or authorities upset. It just gives maximum flexibility, allowing for set up and set down. So it's felt that an hour would be appropriate to do that. Would be operating well into the evening at that time. It'd be part of the race environment. It's just practicalities.
Another one, just to clarify, please. The bus, which has, looking at the bundle, has erotic hats or something along the sides or both sides. Can you tell me what the sort of journey of the bus is around Cheltenham?
No, only this one's been switched on.
The journey to the bus is called upon request, similar to a private hire, I guess. So say you were up at the race course and a customer called the bus, they would come and pick them up and we would take them to the venue. If you talk from a customer's point of view, from a performer's point of view, it will be called from before we open to bring performers to the venue, and once we close, to take performers to their accommodation or their transportation to get home.
Thank you.
Councillor Wheeler.
It just reminded me, and maybe I misheard, but I thought I heard one of the objectors make the comment that the performers don't always take advantage of the transport. Can you assure me how this works? So the performers, because we were told once before they wouldn't be allowed to leave on their own, that they would have to leave the venue with the your transport or safe transport. They wouldn't be allowed to just walk out and catch a bus. Can you assure me how this does work?
So in our evidence, you'll have seen, and I think supporter number 8, not sure I like reducing people down to numbers, but anyway, supporter number 8 stated that these are adults who are self-employed and they choose to come to the venue. The main policy that we operate, and I'll ask Steve to confirm it, is that we will get them into a taxi if that's what they want. We will encourage them to use the courtesy vehicle. The outside area is supervised by our SIA, and in fact, our CCTV covers the area outside that we have our pavement licence for. So we take every effort to ensure that they do that. They will leave in civilian clothes, for want of a better word, to ensure that they blend in with the general crowd. And so those are the measures that we operate. But of course, in the same way that I can't force you to go home by a particular way if you're leaving the council chamber late at night, it's the same with the performers. Is there anything to add?
That's very much.
Thank you.
Any further questions? So I've just got one. In terms of the drawings and the layout of the booths, I know concerns have been raised previously about the size of the booth and how that makes sure that there is no contact. Has that been looked at since the last hearing to address any issues where it's not practical for a performer to give a performance without being so close as to the customer as to make that condition challenging to show it's complied with?
So, sir, you'll actually see that you have a standard condition that you don't impose on this licence because our booths, as set out in the diagrams, demonstrate the particular features of this venue. So, in fact, what they are is quite narrow, which doesn't come across from the plans. They're quite narrow. So, as we've had confirmation, the patron is seated at the end. There is an avenue between all of the booths, which is patrolled. At the foot of the avenue, on the 3 floors where these operate, there is a desk where you'll have paid for your dance, howsoever long that is. At the end of the avenue, so at the opposite end of the opposite from the till, there's a timer that lets the person patrolling know when someone's time has run out. And then, as I've said, the curtain is see-through. So the performer is always closer to the avenue. There is a sufficient gap between the performer and the patron, and they are able to exit quite easily. Equally, because they're there to earn a living. They're not there to give free dances. So, I'm going to love this. So I'm able to pat my instructing solicitor, I'm never going to be instructed again now, I can see her face, and say, time's up, and the performer is able to leave. You might be one of the dream boys. And so that's how that is ensured. They have been inspected. They've been inspected with the police. I don't know if the licensing authority have been. I'm seeing you nod. So there's nothing really been changed since the last occasion.
Thank you. And just one from historically, I know that there was a vicar who was part of the provided, what's the word? They were, their ministry was the horse racing fraternity. I'm not sure whether it was part of the jockey club, and they visited the club and what have you. I just wanted to check, do you know whether she is still visiting and is she still welcome, and are people from that?
She's definitely still welcome, and she visited our club for many years, maybe 6 or 7 years. It's a bit of a sad story. Basically, a lot of pressure was put on her by other people from a similar faith. Her faith was questioned whether she should be in one of these venues, and the fact that she was told that she's not a real Christian if she enters the venue. So consequently, the later years she's had steered clear because it's caused some problems for herself.
Thank you. Right. Are there any further questions? Right. Where are we now? Okay, so I think we'll move to the member discussion. So I'll read the reminder for you. We do have, of course, the option after this to go off and adjourn and take legal advice and formulate more formal reasons. So you don't need to necessarily say everything that you're thinking, but it's just to obviously give those present a steer. So before I open this to debate, I will remind you it is important for you to give due regard to the Council's licensing policy, and if you deviate from that, you need to give clear reasons for doing so. It's important that you only take into account material licensing considerations and that your decisions are reasonable, proportionate and rational. So I don't know if anyone wishes to start. Councillor Wheeler.
Yes, as as I said earlier, this is not a business I'm likely to patronise anytime soon. However, it's a legal business that we are being asked to licence. My considerations perhaps fall into two camps. The safety and security of people working within the venue, both performers, staff and patrons. I think from what we've heard from the house mother in particular, she is happy that the performers are content with the operation. Patrons, well, I'm guessing if they weren't happy, then your business is going to go down the drain. And the staff, we haven't heard from the staff, but my guess is that they are satisfied because, again, I'm sure they would vote with their feet. The other, and probably a bigger concern, sorry, not concern, consideration, is the general public, represented by, in part by the objectors that we've had coming tonight. And it's how the general public will be affected by this business. Now, I think the conditions that we've put on, and even further, not exactly conditions, but comments that the applicants made, conditions they put on themselves to ensure that their business is held within their property, albeit, even if you consider the transport and such the like, it is for the most part kept within the building, and it seems to me that every effort is being made to prevent any outspill, as it were, to the general public. Somebody walking past this business at night may quite easily go past it and think it's just a club. It's just drinking. It's a bar, and Cheltenham's full of bars. You would probably, okay, the signage that's put up, you might be able to work out that it is a little bit more than a bar by looking at the signage. I don't think the signage, even that on the buses, is so offensive that particularly children who may be a little more naive probably wouldn't even recognise. So I think for the general public, I think the securities we've put in place and Erotica have put in place would be good protection. And whereas I do appreciate the concerns for the protection of women, I know women do feel generally insecure at night. I know my wife comes home, if she's got to come home after dark, then she asks me to pick her up or make sure that she doesn't have to walk in the dark. We don't live anywhere near any venue. I think the most dangerous venue to us is probably KFC. Nothing more dangerous than that, and yet she does feel insecure. That can't be put at the door of this business. So generally speaking, I don't see what more we can do unless the Home Secretary decides that they will close the exemption, and then we may be looking at something slightly different.
Thank you. Councillor Steinhardt.
So we cannot use any moral arguments. That's the first point. So despite any moral pros or cons that I may have, I have to disregard those, which leaves me with the dilemma of having a SEV which is licensed and has conditions put upon it, or having an unregulated pop-up SEV all over the place, which are totally unregulated and hasn't conditions. And as far as I'm concerned, we need to be able to safeguard as far as possible the women involved and the general public. And I think the dilemma, I'm afraid, has to land in the fact that at the moment, while the loophole remains, that we are better off granting a licence than not.
Thank you. Any further comments? Councillor Sankey.
Thank you. Yeah, just want to say thank you to everybody who's come this evening. There's been a lot of contributions and a lot of views shared. But I feel reassured that Red Apple have clearly taken every step to ensure the safety of everybody. Yeah, thank you.
Do you wish? So from my point of view, I want to try and go through some of the points. So we've had issues raised about the advertising and about the vehicle. Parliament has said this is a legitimate business, and a legitimate business is allowed to advertise. We've regulated that advertising to control and try to minimise offence to those who aren't interested, hence the not giving the flyers to people who appear to be under 25, to show that the applicant isn't trying to entice minors into the premises. Believe we've got bystander training for those that are giving out the flyers, so there are extra pairs of eyes in the town. If you look at operating a courtesy vehicle, if you go to an airport and you go somewhere, you could go to one of the onward ground transport, you may well be able to get a bus to a hotel. A hotel is a legitimate business, this is a legitimate business. So in terms of those things, whilst they are different businesses, it is still legitimate and the same parallel would apply. In terms of the public sector equality duty, we've got women who have the protected characteristic of sex saying that they cannot, that other women, same protected characteristic, they don't want them working there. That is just something we have to consider. That we have thought about it in terms of public safety for everyone, whether they are working in the club, whether they are walking past a club, whether they are visiting the club as a customer. Having it licensed in one place with conditions is far safer for everybody than the use of the frequency exemption. We've heard it from people that work there, and until the government decide to review this, it's really, really difficult to see how it would be safer for anyone if the venue was in a different location each night throughout race week. There wouldn't be any control on hours. It would be up to 24 hours. In terms of the operating hours, 6 p.m, people have come down from the racecourse. They can go into the venue. They are therefore in somewhere. There are door staff supervising them. They are not congregating on the street for necessarily 2 hours waiting to go into the venue. In terms of the public sector equality duty of religion and belief, the premises is not preventing anyone from practicing their faith. Freedom of expression includes freedom to offend. And if we banned everything that different religions and beliefs said shouldn't happen, there would be no horse racing, there'd be no gambling on the horse racing, there'd be no alcohol, there'd probably be no smoking, there would be no SEV, etc. If we had this under the frequency exemption, the conditions such as one that says, where is it? The performance must not be visible from the street, which would be the case anyway, but any person who can be observed from outside must be properly and decently dressed. Scantily clad individuals must not exhibit themselves in the entrance. Well, past experience of SEV operating under the frequency exemption has people have been observed scantily clad walking across the entrance to be clearly visible. Now, if you are offended by the thought of what is going on in there that you cannot see, I suspect you would be more offended if you could see scantily clad people wandering across the door. So again, the use of licensing conditions seems preferable to the use of the frequency exemption. As was said, the public sector equality duty requires us to think about it and work out, show our workings. It's like a maths exam. You don't get, if you get the wrong answer, you get credit for showing your workings. And what we have to do is show our workings. And the documents have gone, the document provided as a public sector equality or equality impact assessment makes a very useful contribution to members' understanding. You know, it shows a lot of what we have to think about. But the PSED does not mean that we should refuse this. In terms of the grounds, the discretionary grounds, those in support have clearly addressed number A, or letter A, which is the character of the applicant, and there's no question on that. The area it's in the permitted designated area, and that's the current policy. So we would need to have rational reasons varying from that. Really, the only grounds are D, and it would seem to me somewhat irrational for the council to say that somewhere that's in the designated area isn't actually acceptable. It would also seem somewhat irrational for us to allow male performers to use the town hall which we own for sexual entertainment that doesn't under the frequency exemption, while saying that this location isn't acceptable, especially as I think the town hall is actually outside of the permitted designated area, which in terms of the sort of legal rationale, it's very difficult for us to refuse the application. In terms of the taking down of the signs and the banners, that's not one of our standard conditions. That was discussed with the applicant. We asked how long the applicant thought was necessary, and I think the 20 minutes that we've asked to vary was the previous suggestion. And actually getting a condition that's enforceable and workable is more important than really than having the exact amount of time. It's getting it to work, because it's not a mandate, it's not a standard condition, it's something we've done to try and mitigate those sensitivities. I think that probably covers most of the thoughts that I've got. Before I move to the applicant's right to reply, if I can just check with whether there's anything else that you think we've missed.
No.
And licensing. No. Okay. So we may well need to adjourn to just formalise some reasons, but if I give you the applicant's right of reply.
So that's very kind. And as much as I love the sound of my own voice, my mum might agree with me, but I don't think I really need to say anything else. So thank you very much.
So I guess the question for the committee is, do we need to adjourn, or are you satisfied?
No, that's Louis. That's enough from what they've said.
And just to check with Democratic Services, do we need to do this by electronic vote? Or if I think we're satisfied we've got enough reasons from. Right. Okay. So I need to find the part that we are voting on. Bear with me. I'm going up a bit slow, sorry. Bear with me, I'm just scrolling through lots of paperwork.
After this one. Keep going, just next page.
Okay. So if we take this on 7.5, which is, having considered all of the relevant matters, the committee must decide whether to A, grant the application as applied for. So can I have a show of hands for those in favour of that, please? So that is unanimous. The application has been approved, and the decision notice will be issued in due course. Where are we? So we were scheduled to go into exempt session for some other items, but both of those items have been deferred on the grounds that those involved didn't have legal representation, and legal representation wasn't available. So we have agreed to defer that to the next meeting, and the drivers remain suspended so that there isn't a public safety issue. And there are no other items which I determine are urgent and require a decision. So at 8:25, I declare the meeting closed. Thank you.